Well, good morning, good afternoon. Welcome to the next of our Mosaic coffee breaks, and we're delighted to have with us today Anne Harrison. And I was about to say, yeah, formerly of Stevenson's, involved with the SRA, but maybe we'll leave Anne to introduce herself.
Yeah, thanks, Mark. Well, yes, I'm formerly of Stevenson's. I spent most of my working career involved with Stevenson's and a partner there. Retired in April 2020 after nearly 30 years with the firm and 15 years on the senior management team there. And for people who don't know, Stevenson's is a top 150 law firm, consumer focused, but quite a broad range within that, and increasingly doing more work for local authorities and government organisations. So I retired from Stevenson's, stepping down from the position of chairwoman. I was at the time involved with the law management section. In fact, I was chair of the law management section, had been for some 3 years. I've been involved with the LMS since I think about 2010, something like that. I saw a position advertised for the board of the Solicitors Regulation Authority as I was coming towards the end of my tenure with LMS, and thought, well, that would be interesting, wouldn't it? Seeing things from a different perspective, perhaps. And I thought maybe some of the skills that I used whilst I was at Stevenson's might be helpful there. So I applied for it, never really thinking that I would get it, but they did say that they were looking for someone with experience of a high street firm, which of course was right up my street. Anyway, I was appointed to the SRA board and had been working with them since January. There are 4 new appointees. We came on the board together. And it's been really interesting. I found out a huge amount about the regulator and how they operate. And I've learned a lot about the profession as well, I think, in doing so, different sides of the profession to where I've come from.
Interesting. And are you still connected with LMS, Anne, or have you left that committee?
I had to step down because of the conflict. Right. I didn't really want to, but it clearly is a perceived conflict between the regulator and the representative bodies. So yeah, I had to step down. I'm still friends with everybody there, though.
Sure.
People.
Just picking up on what you said, then you said you'd learned about the profession from that, probably things from that different perspective. What sort of things are you seeing differently?
I think the position and role of the big city firms, which I've never honestly given very much thought to, because it's just not really been on my radar, either with Stevenson's or indeed with LMS, which is targeted at mid-market firms. But I've very quickly come to understand that, of course, the commercial firms have their own particular outlook. And if we're going on to talk about SQE, it will be interesting to think about how what I've heard about how they are viewing the SQE. But it's a very different approach, and their needs, of course, are completely different to the needs of what I would consider to be, well, I was going to say the bulk of the profession, but it's not actually, because the bulk of solicitors work in the big commercial firms. But what you might say is it's the bulk of the numbers of firms, the smaller firms, the high street firms and the sole practitioners. There are more of them in numbers than there are city firms. But it's almost like, well, it is, isn't it? 2 extremes of the same profession. And we all know that everybody all the firms in our profession are very, very different and individual. But when you look at people like Clifford Chance and Freshfields and compare them even to, say, Stevenson's or to certain sole practitioners, now the twain shall meet, it really is like chalk and cheese.
Yeah, you say, sort of different ends of the same profession, in some respects, they look like different professions.
Yes.
They're still using the law and regulated by the same regulator, but it's interesting whether the same set of rules really can work with such diverse organizations.
Yeah, I think that's a very good point, Mark, and I suppose that's why so many of the the regulations that we are subject to have to be at a very high level. And I do think that the way things are set up now, with principles at a high level for people to interpret, makes it much more accessible, if you will, for firms, whatever the nature or remit of the firm, size, shape, whatever.
That's good. I mean, you mentioned SQE, and I was thinking this is interesting because it's not an area we've ever talked about, I think, on one of our Mosaic coffee breaks before. You know, we tend to focus very much on sort of things that the partners, the owners can do to deal with issues. But actually, of course, training new people entering into the profession is key. So you obviously, I mean, I've read the articles, but wouldn't claim to fully understand it. We're very small, so we don't have any trainees. So I've not needed to understand it. So do you want to, could you give us sort of a nice little overview of that, Anne?
Well, it's changing the way that people qualify into the profession completely, because now, as of September this year, there is one qualifying examination that is common to everybody right across the profession. The old articles of clerkship or trainee solicitor 2-year periods of work have gone out of the window completely. And as long as you have a requisite work experience period and you can pass the SQE, you can be a solicitor. And there are, as I understand it, there are no restrictions as to who can sit the SQE.
So you don't need a degree. You just, you sign up to say, I want to sit the SQE, and if you pass it, you can call yourself a solicitor if you've got the required work experience.
I think that's exactly right. So I think it's going to, well, it will make firms think very differently about how they have their NQ intake, whether it's a large firm or a small firm. I've heard of some firms who are saying, well, we're just not going to think about it anymore. We'll just recruit from qualified people, really qualified people, and let other people worry about it. I'm not sure that is the best way forward, but I've heard that is one approach that is being bandied around. I think there are dangers with it. I can see what they were trying to do. I can see exactly where we're trying to go with it, to make it, to open it up to absolutely anybody who wants to come into the profession. And I think that is a good thing in terms of equality and diversity, of course. But I think there are possibly two, I don't know if they're unintended consequences, but things that we will see that aren't quite as how we would want it to be. For example, we talk about the difference between city firms and smaller firms. And we're already seeing examples of city firms requiring more than the basic SQE. And some of the law colleges and some of the educational establishments are working with the city firms to deliver courses for sort of SQE plus, if you will, because the commercial firms are saying, well, we want more than the basic SQE, which is all very well, but that then restricts social mobility, I suppose, because if you haven't got one of these SQE plus qualifications, chances of getting into a city firm are going to be quite difficult. And then the other thing that troubles me a little, and I'm not sure how you can control this, is that it's going to be more expensive, I think, because people are still signing up to courses to get them through the examination, akin to almost the old LPC. But then you've got the cost of the exam itself on top of that now, because I don't think these courses are costing any less than the old systems. So in terms of social mobility, which is something which is very dear to my own heart, I think that is possibly going to be a retrograde step. But I think it's very early, isn't it? And we'll have to see how things develop. I do like the idea of consistency across the qualification. And I think that was one of the objectives behind bringing it into play, because there was, shall we say, some inconsistencies in the levels of education being offered to people.
Forgive my ignorance, Anne. Is the requisite period of work experience, is it still 2 years?
Yes, but all of the structures around that have gone. So there is no need to do specific seats or
Right.
to be specific. So if someone has, for example, has worked as a paralegal for 2 years, not under the guise of any sort of training contract, they could then go and sit the SQE and then say to their employer, here I am, I'm qualified now, you have to sign and to say that I have worked for you for whatever the period is, the 2 years.
Right.
But
And whether there is actually a solicitor's job available for them.
that was my question. So, you know, the paralegal who's been there for 2 years goes off, takes the SQE, passes it, goes back to their firm, and the firm says, lovely, well done, you're a qualified solicitor, you can continue being a paralegal.
Yes. And I think that's going to take some thinking about for quite a lot of firms when they have people in that situation. And what are the options open to them? Either to say, oh yes, you're a very valued employee, you're now a solicitor, we'll pay you a solicitor's salary. Or to say, well, actually the role that you're doing is not a solicitor's role. It's somewhere at paralegal level. So if you want to be a solicitor, you're going to have to go and do it somewhere else or apply for a different job. And I think we'll see that happening.
One of the things that a lot of small to medium-sized firms have done in recent years has been to use the promise of a training contract to help recruitment at paralegal level.
Yeah.
And it's been very difficult recruiting at that sort of level. That's been a very, very useful lever. What you're saying is that opportunity is now gone. You can't promise people a training contract because they'll be non-existent. So presumably that could make things tougher in recruitment and retention at the more junior end of the market.
Possibly. I'm sure that firms are clever enough to put a spin on it and say, if you're wanting to take your SQE, come and get your relevant experience with us, and then not promise a sister role at the end of it. There will be ways around it, I'm sure, to keep attracting young people into the marketplace.
And how's it going to work? Because I think the legal providers are very interesting, because I came to law late in life. You may recall, I used to have a proper job, and so when I did the didn't say that when I did the GDL and LPC sort of 20 odd years ago, there weren't very many providers, and the question I always asked was, how many people do the LPC, and then how many trainee solicitors jobs are there? And it was sort of reasonably balanced. Then you got all these people piling into the market, and there were loads of people coming out with LPCs, way more than there were trainee jobs, which caused the problem. Now here, if anybody can go and sit the SQE, is that just going to make that worse? Or maybe linked to that as a question, would it be possible for somebody to sort of buy some books and self-teach them, or do they need to go to one of the BPP, University of Law type providers?
I think that's another interesting question. I think the answer is no. They don't have to sign up to any sort of educational course. They could, as you say, self-teach just through the books and through their own experience if they've been working in a law firm, and have a go at it there. But from what I can gather, from what we're seeing, most people are signing up to some sort of course, and all of the usual providers seem to be there in the marketplace. The main ones, the BPP and the University of Law and what have you. Not sure where the smaller ones will go with it.
And with another hat on, you're very involved in the educational field, aren't you? Do you see the colleges moving into this in any way, or do you see online further education moving into this?
Well, I think it's an opportunity for not just FE colleges, but also the universities. And something that we haven't mentioned at all, but which I think is something that we'll see more of in years to come, are the potential to carry out apprenticeships.
Yeah.
I was going to say that seems to me to be a growing field, and one of my clients, and a client Nigel knows well, who's a managing partner, has just got her MBA through the apprenticeship scheme.
Yeah. Well, yes, yeah. But I think I was talking about social mobility. And whilst I do fear that there are problems with the actual cost of doing the SQE, the potential to undergo an apprenticeship over 3 years, 5 years or whatever, I think that could be really good for SQE. It's almost like coming full circle. Even long ago, even before I was doing my own articles of clerkship, as they were, you used to do, you had the potential to do a 5-year articles without a degree. And that was the way that people qualified. And it's almost as if we're coming back to that level. And I know that at Stevenson's, they are using apprenticeships to good effect, up to paralegal level. And then you can jump sideways and get onto the higher solicitor qualification apprenticeship. So I think the potential to do that is quite remarkable, really. And I can see that is a very good opportunity for social mobility.
Well, it'd be nice to look back on this in 10 years' time, wouldn't it, Anne, and see what impact it's had, because it's easy to foresee 20 to 30% more solicitors on the roll in a period of time, and many of them without jobs.
But that was happening anyway, Nigel, wasn't it?
Yeah.
People were coming out with an LPC and either not able to get a training contract, or even worse, getting a training contract, finding themselves qualified and then not being able to get a job. So I think that was happening anyway.
Yeah.
So it'll be interesting to see whether this wholesale change means that the market changes.
Yeah. And talking of change, sorry, Mark.
I was going to say, and and it is the cost that you mentioned before, because I think even you're saying the SQE could cost even more. But I think if somebody came through a degree, and I worry for my own children, who come out of university with 50, 60,000 pounds worth of debt, and then if you want to do an LPC, it's another 20,000 or whatever it is with living costs. It really puts off people from the social mobility, and what's the cost?
Yes, but that was the same under the old system, wasn't it?
Absolutely.
When you're talking about numbers like that, 50, 60, 70,000 pounds, another 1,600 pound on top of it isn't going to break the bank. But it may put some people off, I think.
Good. I'm conscious of time here, so let's wrap up this session and say thank you to Anne, but we are going to record straight away another session which we'll publish separately on some other topics. So thank you, and we'll see you soon.
Thank you, Anne.
Thanks, Anne.
Thank you.